Staat zijn klaar. Als we nog niet zo veel, dan is het crimineel. Staatsbrokaderie.
Thank you. You may be seated. Thank you. General, you're under your previous oath. Advocate Otamo.
I understand, Justice.
Thank you.
Thank you, Justice. Justice, I've noted two issues which we had to take instructions. One regarding the service of the statement, and then second relating to the warrant of arrest.
Yes.
And I will deal with them in turn.
Thank you.
Justice, as we are aware that on the 17th of August 2017, Dr. Ginoshi was called upon to appear in court to provide certain documentation. At that hearing, there was an affidavit which was deposed to by the doctor indicating that he was not in possession of the documents. And we have a copy of a document which records service on the Colonel Ditabo, where he had acknowledged receipt of the affidavit, which also bears the stamp of the South African Police Service.
Let me get it right again. The affidavit before us is of the 11th of September,
Indeed.
2017, but you say that earlier than that, the doctor was required to appear in court on the 17th of August.
Pursuant to the subpoena.
Pursuant to the subpoena.
Yes.
Very well. And did he make an affidavit?
Yes.
Did he make an affidavit before the one of the 11th of September?
Indeed so, which we will make an effort to make it available. But
Yes.
what we have now is a document which proves that it was indeed served on the Colonel, and
Yes.
which bears all the details, and it was received on the 16th of August.
Yes.
And after the receipt of the affidavit,
Now, 16th August was receipt of what? Of Dr. Kinoshi's first affidavit.
first affidavit,
Thank you.
prior to appearance in court on the 17th.
Yes.
Then, in light of what was contained in the affidavit, the NPA, the prosecution, was not quite content or satisfied with the content. They required more to be done with regard to the making of documents available.
We're not happy with Dr. Kinoshi's, the
Affidavit.
content of Dr. Kinoshi's affidavit. Right.
Indeed.
Okay.
Which then, in order to ensure that there is compliance, through the discussion of the parties, the NPA found it necessary that a warrant of arrest be issued so as to ensure that there is compliance with the request made. The warrant was issued for purposes of ensuring that the documents were made available. So my instruction is that that warrant was issued on the 17th of August by agreement between the parties.
To ensure compliance or to ensure attendance?
Through the discussion, it was to ensure that there is compliance of what was required of the doctor, failing which it will be given effect to. The warrant will be given effect to. So that explains the last paragraph of the affidavit, which appears at paragraph 22.
But isn't it strange that the warrant of arrest is issued in order to compel the doctor to provide information? Warrant of arrest is normally issued to secure attendance, not to compel answers.
I do follow that, Justice, but that's the information from client with regard to what had actually occurred.
And was a warrant issued by a presiding officer, by a magistrate?
I am made to understand so, yes, through the request of the prosecutor.
And there was no claim that Dr. Kenoshi had not appeared in a previous hearing? No?
As I say, the instruction is that what was agreed between the parties was that in light of the content of the affidavit, in response to the request of documents, the prosecution wanted to ensure that there is proper compliance. And what the parties agreed, in order to give the assurance that indeed effort will be made on his part, that's when it was agreed that the warrant be issued.
On that account, counsel, is that warrant a valid warrant in law?
Justice, I will not want to debate the validity of that warrant, as I have not seen it, but that is the instruction which I have. And in seeking to explain why in the affidavit the doctor sought that such a warrant be discharged.
Yes. Understand.
And if I can just hand up the proof of service is LR 47.
But we know now there's proof of service of the affidavit, the first affidavit.
Yes.
Of the 17th of August.
It's LR 47, and the proof, in fact, appears at LR 48.
Yes. Who would have made the endorsement at the bottom of LR 48? Do you have a copy of LR 48 and LR 47, General?
I do have.
You do have them very well, thank you. Counsel, who would have made the endorsement at the bottom of LR 48? Is it Lieutenant Colonel Ditabo?
That is my instruction.
And when he was served with this, then he wrote, I presume on the original also, that the information provided is not sufficient. It is advisable for your client to avail himself in court on the 19th of August 2017.
Indeed, so, Justice.
So the view of the colonel was that the information provided in the affidavit of the 17th is inadequate, and therefore the doctor has to appear in court on the 17th of August.
It is indeed correct.
I see.
Yes.
Understand that. You may proceed.
And then pursuant to that arrangement having been made, the matter was then postponed to the 20th of September.
Yes.
And then it was during this appearance that this affidavit, LR 46,
Yes.
was made available to the member of the task team, Lieutenant Colonel Ditabo. And it is the affidavit which enlisted the documents provided.
Yes. And was served on the colonel with a view to satisfying the requirement or the demand for information.
Indeed so.
And what happened to the case then? On the 20th of September,
On the
after the affidavit dated the 11th of September was served, an appearance on the 20th, and what happened there?
my instructions are that on the 20th of the 18th, like I beg your pardon, Justice, like the date is supposed to be the 18th.
Of September.
Oh, no, sorry. The affidavit was indeed provided on the 20th of September, and from the documents which were provided, there was
I don't understand that. Affidavit is, excuse me, the affidavit is deposed to on the 11th of September. It's attested on the 11th, is it 11 or 17?
11th.
11th of September. And when was the appearance to be?
The appearance was set for 20th September.
20th. And what happened on the 20th of September?
Then on the 20th of September, my instructions are that there were further documents which were provided to the colonel. And the arrangements...
Other than those set out in the affidavit?
Indeed so.
Yes.
And the matter was subsequently postponed from the 20th of September.
Excuse me.
And it was postponed to the 18th of October.
Why?
There were further documents which were requested over and above what was provided.
In other words, even after the affidavit of the 11th of September, it was necessary to provide further documents, and for that reason the matter was postponed to the 18th of October.
Indeed so. And then on the 18th of October, another set of documents which were requested were provided to the colonel. And in fact, this time, they were given to Colonel Ditabo, who is a member of the task team, in the company of Captain Madisha. And the prosecutor as well was present, prosecutor by the name of Giselle. Those documents were provided to them on the 18th of October. And by agreement between the parties involved in the proceedings, it was agreed that the police will consider those documents and consider if there are further documents which may be required. And to date, that indication has not yet been given.
But the case was postponed then to which date?
To the 6th of December.
6th December. And why was the subpoena not set aside?
In light of the further documents which were being made available from time to time.
So one subpoena was issued, and then there were all these spurts of documents that were provided.
Indeed so.
Very well. Thank you for that. Subject to anybody contesting that will need evidence. But so what do you want to put to the colonel now? I'm sorry, to the general now.
Thank you, Justice.
And thank you for the information, Counsel.
Thank you. Major General, I want to put it to you that despite you being the head of the task team, you have not been properly updated about the interaction between the department and members of your task team. What's your response to that?
Thank you, Justice. That is not true. Let me put to the tribunal that I was briefed on all the court dates and the reasons. During the break, I consulted with Colonel Ditabo and Captain Modisha, who is present here. Our version is the following: that the 205 subpoena was served. The doctor had to provide the information, required information, by the 17th of August, or appear in court to provide the reasons why the documentation, the requested documentation, was not provided. By the 17th of August, we did not receive the requested information. The doctor did not appear in court. Only the legal representative M&S attorneys were present. Because there was non-compliance with the subpoena and non-attendance at the court, a warrant of arrest was issued, but it was held over until the next court appearance, which was the 20th of September. We do not dispute that Lieutenant Colonel Ditabo received the document ELH 47 and that it is his signature and his handwriting on ELH 48. Now, on the 20th September, there was still partial compliance with the documentation. The doctor was still not at court, only the legal representatives. It was then agreed that the matter be postponed until the 18th of October to provide the department time to comply with our requests. Again, there was partial compliance. And the doctor was also not at court on the 18th. Upon mutual agreement, the warrant of arrest was still not authorized for execution, but it stood over for the 6th of December because there was still not full compliance with our request.
So the warrant is still
Valid, although it has not been authorized. The agreement between the attorneys and Advocate Giselle van der Westhuizen, who is part of our team, who is representing the NPA, is that firstly, there will be full compliance before the 6th of December, failing which Dr. Kenosi must appear on the 6th of December. And there was agreement that the doctor will be at court on the 6th of December. So, up until today, Justice, there is not full compliance with our request. But I took note of the paragraph where the doctor proposes a reconciliation of what we have and what we don't have. We will take up that offer and see whether we can do it before the 6th of December.
Counsel, you've had the response to your propositions.
Indeed, sir.
And the reasons why the warrant was issued but held over to the next hearing. Any further questions from you?
Major General, I put it to you that the officials, and in particular Dr. Kenosi, has been making every effort to assist with regard to the documents which are required by the police. Will you dispute that cooperation?
I don't know what efforts the officials are putting in place. My viewpoint is that there is not full compliance with our request.
And the doctor has made it clear under oath that for any information which is outstanding, that will be made available. And as I've indicated earlier on, there's been documents which have been made available to you, and the arrangements which were made by members of your task team, including the prosecutor, who is a member of the task team, was that they will consider the documents made available to them and consider if there is any further documents required. And to date, that indication has not been given. Will you dispute that arrangement?
I don't agree that there was this arrangement between us and the department to come together. What I'm saying now is there is still not full compliance. Seeing that this affidavit was brought to my attention today, I will do everything to see whether we can meet before the 6th of December, agree what in writing with signatures as to what documentation we still need, and by when, before the 6th of December, the department will provide with us in line of paragraph 19 of this affidavit.
That will be helpful, and we mustn't drown in detail unduly. The question that was put was, is it true that Dr. Kinoshi provided the full documents that you asked from the department? And the answer from the general was no. The next question was what when Dr. Kinoshi said he did, was he being candid and untruthful? And the answer was yes, he was untruthful. That's where all this comes from. And the general's position has always been not all documents have been provided. And Dr. Kinoshi's position seems to be, I have given some documents. So the difference is that thin. Have we given all? The answer is no. And all these subpoenas show that not all information was given, at least prima facie, counsel. You could argue otherwise. So we should not lose focus. We should make sure all the documents are provided. And it's undesirable to have warrants of arrest against high-ranking officers all around providing information that is vital to building up proper dockets for possible prosecution. So I don't want to get unduly and overly sidetracked by what we are about. We want to see those who might have committed offenses being held criminally liable. So I hope that come that December date, and the general has offered to do the recon earlier than that. It should be done, and the information should be made available so that we can build, the police can build proper dockets. So prosecution must ensue where it is due without all of these coercive measures from one State Department to another. Is there anything else that you want to say or to ask in the light of that? In the light of the offer by the general to go and look at what you have and say what he still needs?
Well, in conclusion, I just want to state to Major General that with regard to his concession that he is willing to have a look at the documents which are still outstanding, is in line with the version put to him that on the 18th of October, documents were provided to members of the task team, and they are yet to give an indication if there are still any documents outstanding.
So let the witness respond to that. You've just put it to him. And the general hears you. General, do you want to respond to that?
General, Justice, there was a mutual agreement between the state prosecutor, the attorneys, and the investigation team leaders that there are still documents that was not provided, and some of the documents that were provided does not fully comply with our requests. Therefore, the department was given a due date for 6 December. So that's all that I can say relating to the statements or documentation that are still required.
Counsel, do you want to proceed any further?
Thank you, Justice. If you can, I can just take instructions. Those are the questions on behalf of the government. Thank you.
Do you know why the Dr. Kinoshi did not tell us when, with this evidence about all of this?
I'll not be able to proffer
You'll
any
not be able
answer.
to say that.
Yes.
And for us to hear it from the police when they express the challenges that they have to meet. Anyway, I have to come back to you, Advocate. Thank you, Counsel. Thank you very much.
Justice Msaneke, just one...
Re-examination?
Yeah, just one point to re-emphasize. Major General Johnson We have been asked several times, specifically by Advocate Groenewald as well as Hasim, that is on behalf of Section 27, that there has been information placed at your disposal, and the answers coming from you were that if the evidence reveals some criminality, then you will bring charges or you follow that evidence and so on. I just want to put this to you, this proposition to you, that what they had been asking of you is that information has been presented to you in the form of statements. You had been referred to on page 11, 17 and so on in volume 3. And I want to indicate or take you through to some specific passages just to demonstrate the point so that you understand what the questions were all about. Specifically, let's go to volume 3, page 1120. Are you there?
Yes, Justice.
Yes. On 1120, paragraph 11.3, that is the last sentence of the paragraph, which reads the suspect.
Again, let's qualify the document, please. What document are you putting to the witness, of which date, authored by whom?
The document you had been referred to by Section 27 in cross-examination. It's on page. It starts from page 1117. A letter by Section 27, dated 20 September 2016. You still recall this letter?
I do, Justice.
Yes. On the very same letter on page 1120, paragraph 11.3, the last sentence of the letter, it reads, the suspected cause of death is an overdose on her mental health medication and so on. That is the part of the letter I seek to refer you to. Then the second letter appears on 1171.
Can we ask the witness what we want to say about that?
So,
Witnesses thrive best when they've short, pointed sentences. Then you can take them to have a document when you're done. What do you want the general do about what you've referred to him? 11.3.
what appears on 11.3 is that you are given information that this is the information you must follow. And from this information, if you follow it, the evidence would come to you. Then the evidence will show some form of criminality, and this is what you had been requested to follow on. Do you get that?
I get it, Justice, but what I want to say is I indicated that it's the first time that I saw this document and that I will make work. If I get a copy of it, we'll certainly look into this specific matter with a view of opening a criminal docket.
And the same appears on page 1118 of the long letter of 24 pages, which starts at 1171. You are referred to.
Again, it's a letter from Section 27, dated the 28th of March.
You have been cross-examined on this letter as well. You are referred to there on page 22, then on paragraph 22, page 1181. There are numerous passages where these instances are specifically referred to. And in the middle of that paragraph, it says, a person who is not a health care worker of any sort violates Section 39 if they make any formal medical assessment and so on. And that too is an instance of a violation of a statutory provision to which your attention is drawn specifically to attend to. As well, on page 1182 of the same letter, and with reference to section 17.2 of the National Health Act 61 of 2003, about a person who falsifies any record by adding to or deleting or changing any information contained in the record as well. Your attention is drawn to that specific provisions of the statutory provision. Then the last passage I want to draw attention to, on the same letter, it appears on page 1185, and this specifically refers to the MEC. I'm sure you will recall being asked by Advocate Groenewald that they did not hear you that you are investigating any case against the former MEC or any other of the senior officials and so on. And specifically I refer to there on the page, that is paragraph 37, which reads specifically, section 17, subsection 2E, creates an offense for any person who willfully furnishes a house or committee with information or make a statement before it which is false or misleading and so on. So there are numerous passages. I'm not going to read, take you to each of them. They are there. So what I want to emphasize to you is that your answers that if evidence reveals that there's some form of criminality and so on, you will follow it. This is what you had been requested to specifically draw your attention to.
I agree, Justice, and I took note of the passages. Yes. We will direct our investigation to this.
Yes. And with what we have all collated here in this hearing, you may get a lot of what you want. There are bundles of documents here which have been, they run into, I don't know, 10, 12 volumes. So there may well be a case to be made out for your accessing a bundle of documents here that contains a variety of valuable material that would help buttress your work as we go along. And some of the documents may very well disclose probable or prima facie commission of offenses. So if you made arrangements with these advocates here, I'm sure we can make available the documents we have, which are quite many. And your team could get more information than they might have had up to now, including the record of proceedings. It's a public record. There's no reason why it shouldn't be available to the South African Police Services. Are you done, Councillor?
Thank you, Justice Msaki, I'm done.
You are, and thank you ever so much. I'd like to thank you, Council, both of you, as well as you, General, for facilitating your appearance here. It was very important and a valuable part of the evidence we need and the sense of closure that might develop, because there can't be closure unless if the crooks get away with it, is it? If something has gone wrong, there are many levels of retribution to get that balance back. You might remember Lady Justice with the sword and the scale. And those levels might be arbitrations like this, and equitable compensation. Another level might be criminal responsibility, where it is present. So your work will be a very vital part of this whole healing process. And people are convinced that there are officers, high-ranking officers, who are prepared to do their work and to do it properly. It's your time to say your swan song, if anything at all, Major General.
Thank you, Justice. I just want to say thank you for the opportunity that were provided to us as the South African Police to come and put to the tribunal what we are doing and what is our attitude towards this investigation. Because it seems to me that there is a perception, whether it's true or not, that the police is totally doing nothing or dragging our feet relating to the investigation of this serious matter. I'll have to consider, based on the documents that is going to be provided to us from the tribunal, hopefully as soon as possible, that I should establish a subsection of the team with more members that would then have a special focus on investigation of possible criminal matters based on evidence that we are going to be provided with, so as to have a dual type of investigation, accounting for the deaths and accounting for possible criminal conduct relating to the deaths. So I think that would be a more strategic way of approaching the investigation. But thank you once again for allowing us to come and inform the relatives and the public about our seriousness relating to the investigation of this matter. And thanks for the direction that was provided from you, Justice, and the Council as to how it is expected of the police to deal with these matters and the direction relating to, excuse me, possible criminal conduct of specific individuals. Thank you very much.
Thank you, General. Once more, thank you for being here, and we much appreciate that. I'm sure the families do too, and I think South Africa does too. We're going to adjourn till tomorrow. It will still be 9:30, so there'll be no discount because of the late sitting. We'll be sitting from 9:30 tomorrow, and I've no doubt that all counsel involved have organized their witnesses for tomorrow. Once more, thank you. We are adjourned.